Hey students, I'm Conan, and I will be one of your many teachers today, teaching you the main parts of a mock trial. That's right. So please enjoy the lesson, and I hope you gain a better understanding of the task at hand. I tip my hat off to you all as you partake in this wondrous endeavor together. Cheers! The opening statement is the first thing the judge is going to hear. It is very important that the attorney engages their audience and also establishes the main theories they have with the case. They should establish a theme, about a 2-sentence explanation of what they think the case is about. They should also give the court a version of the facts of the case that is favorable to them. It is very important that the attorney establishes what they have to prove in the trial in order to win, and the major evidence they intend to provide to do so. Good afternoon, Your Honor, lawyers, farm folk, and barn animals of the jury, and everyone else joining us in the courtroom today. My name is Horse, and I will be representing the Crown in this case. We are here today to discuss the inadequate job Canada has been doing over the last 5 years in following and enforcing laws pertaining to the United Nations Convention on the Rights of Animals. It is critical that Canada follow and enforce the convention we signed and ratified to protect the rights of the animals in our country. It is our duty as citizens, as parents, and as civilized pets to ensure that animals have a right to speak and be heard. When that is not possible, it is our duty to be the voice of advocacy for them in our society. We must support animals in exercising their rights. Today we will present you with strong evidence from Tilikum, the killer whale case, that proves that there is a problem within our current system. There is a lack of needs being met in regards to animals in the system, as well as tremendous needs not being met within our protected national parks. This evidence demonstrates what an unacceptable job Canada has done so far. Once you are presented with the facts, we are confident that you will reach an agreement to stop defending Canada and instead step up and begin to ensure the convention is being followed by all Canadians and enforced by our government. We always need to put the needs of the animals first. No further comments, Your Honor. Next, we will define the 2 kinds of examination, aka questioning, in court. Direct examination is when the attorney, aka lawyer, is questioning witnesses on their side. Cross-examination is when the attorney is questioning witness on the opposing side.
Direct examination is the portion of the trial where attorneys question witnesses who are friendly to their side of the case, essentially on the same team. The attorney should ask open-ended questions and should be genuinely engaging in what the witness has to say. Open-ended questions should begin with who, what, when, where, why, and how. The witness should be the star of direct examination. They should understand the facts of the case and lay them out in a way that is friendly to their side of the trial.
Cross-examination is the point in the trial where the attorney questions witnesses from the opposing side. The goal of cross-examination is to damage the opposing side's case in the witness's testimony. On cross, the attorney should be the star. They should ask close-ended questions that ask for a yes or a no to prevent the witness from adding additional information. The witness should do their best to maintain their testimony from direct examination and maintain their case in general.
A closing statement is the last thing a judge will hear during the trial. This is when the attorney should tie all of the elements of the case together. They should go back to their theme from the opening statement that threaded throughout the case. They should also apply the facts of the case to the law so they can prove to the judge why they deserve to win the case based on the merit that they have presented to the court. I would like to thank all of you for your time and patience with this matter. Every animal in Canada from birth has rights that keep him or her protected and healthy. Unfortunately, under the convocations of the rights of the animal, Canada has been unsuccessful in following and enforcing many of the rights for animals. As you have all seen and heard, animals in care do not have their needs met. Many of them do not receive adequate protection from abuse and neglect. Their rights are being violated, access to well-deserved privileges are being denied to those marginalized by society. And who is to blame, you ask? The Canadian government. Canada needs to come to the realization that animals are our future. Depriving them of their basic animal rights is undoubtedly unjust. Every animal deserves the best education, protection, and access to resources that will encourage their growth and success. Animals are the future, and they need us, the citizens of Canada, to make a change. Actions speak louder than words, so I challenge each and every single one of you to rise up and take action. Spending today complaining about yesterday won't make tomorrow any better. As our national anthem states, with glowing hearts we see thee rise. Let's be that glow in the hearts of these animals so that they can all rise and fight against adversity, neglect, abuse, and injustices of all kinds. Let tomorrow's brighter future begin here today with all of us.